In this installment of Washington Legal Foundation's Legally Brief, Hans von Spakovsky, a senior legal fellow at the Center for Legal and Judicial Studies at the Heritage Foundation, will critique a proposal which would inject the federal government into the creation and registration of new businesses, an area traditionally governed by state law.
The Heritage Foundation recently published a paper on the Incorporation, Transparency, and Law Enforcement Assistance Act, or ITALIA, being considered by Congress. Senate Bill 569 is sponsored by Senator Carl Levin, and it would subject private and closely held businesses to burdensome reporting requirements, increasing the cost and liability risks of business formation and maintenance. American entrepreneurs form approximately 2 million limited liability companies, or LLCs, and corporations every year. The vast majority of these are small businesses, often family-run companies, that will never issue regulated securities or get traded on any market. For that reason, they are exempt from the complicated and burdensome reporting requirements of laws such as the Sarbanes-Oxley Public Company Accounting Reform and Investor Protection Act of 2002, laws intended to protect unsophisticated investors buying shares in the public market. Such laws put American companies at a competitive disadvantage against foreign rivals and will have severe consequences for smaller businesses that cannot afford the cost of compliance. Many economists agree that the Sarbanes-Oxley law has harmed the U.S. economy and its financial industry, and the ITALIA Act will have the same effect on smaller companies and businesses. In essence, the proposed law would mandate that states require those forming new corporations and LLCs to provide the state with a list of the beneficial owners of the business. While this may sound benign, it is not. The Act has a very vague and very broad definition of beneficial owner. It's any individual who has a level of control over or entitlement to the funds or assets of a corporation or LLC that, as a practical matter, enables the individual directly or indirectly to control, manage, or direct the corporation or the LLC. You would have to provide the name, address, and means of control of the beneficial owner, such as through a partnership or a trust. If the owner is a foreigner, individuals forming the business would also have to certify the identity of each owner who is not a citizen and obtain a copy of their passport. This information would have to be disclosed upon receipt of a written request from a federal agency on behalf of a foreign government and in response to a subpoena or a summons from a state or federal agency or a congressional committee. Anyone forming a corporation would be considered a formation agent and included in the definition of financial institution, along with banks, credit unions, and the like, thereby subjecting them to record-keeping and reporting requirements under existing federal law. Individuals not complying with this law would face potentially severe civil and criminal penalties, including imprisonment for up to 5 years and fines up to $250,000. The problem, of course, is that the definition of beneficial owner is so vague it raises more questions than answers. Because there's no clear-cut definition of owner, it would require a loose, subjective analysis to determine the legal requirements. Since it requires reporting anyone who directly or indirectly controls, manages, or directs the business, even family members who exercise informal control over a closely held corporation could be considered beneficial owners. Thus, the owner and president of a small company could be compelled to report the extent of informal control that her spouse and father-in-law exercise over her decisions. Does any percentage of ownership, no matter how small, make an individual a beneficial owner who has to be reported? There's no way to know. The definition of beneficial owner also requires piercing the corporate veil, requiring businesses that are partly owned by another corporation or a trust to report changes in the ownership of that other entity, including the beneficiaries of a trust, or tracing the ownership of corporations that are in turn owned by other corporations vertically all the way up the chain until they reach individuals, an extremely arduous and potentially impossible task. Why is this legislation being proposed? Well, it's being done at the behest of the Financial Action Task Force, an intergovernmental organization established by the G7. It is supposedly intended to combat money laundering and terrorist financing, but of course, it would not accomplish that end. A criminal intending to launder money or finance terrorism is not going to provide accurate information on the beneficial owners of his business. It's only legitimate business owners that will try to comply at great cost, great risk, and great inconvenience. This common sense fact has been recognized by other countries such as the United Kingdom. The preamble to this bill incorrectly states that all countries in the European Union have implemented these requirements. That is false. In fact, a report issued by the task force itself in 2007 pointed out that the United Kingdom had declined to make these changes because there were significant disadvantages and no clear benefits, particularly when taking into account the costs of introducing such measures. Their reasons included that those engaged in criminal activities would not provide true information about the beneficial owners, and such disclosure would result in misleading information being publicly registered and potentially harming law enforcement investigations. Finally, the IDLEA Act raises significant privacy concerns because it requires detailed disclosures of information on privately owned businesses, businesses that are not listed on stock exchanges and whose shares are not generally open to purchase by the general public. This breaches the privacy of business owners and may cause those concerned about privacy to forego certain business opportunities, thereby taking their funds and possible jobs out of the stream of commerce. The law is unneeded. Our Constitution and federal criminal laws already provide law enforcement agencies with the authority to obtain information needed for a criminal investigation. At a time when America's economy can least afford it, this proposed law would reduce the number of new business formations, hurt small businesses, and provide little deterrent to criminals who could easily avoid its requirements. If you'd like more information on this bill, you can obtain it at the Heritage website at www.heritage.org in Legal Memorandum number 48.